Okay, so most of us think of ourselves as law-abiding, God-fearing folks, and we know how our parents raised us. Maybe the worst we've ever done involved a traffic ticket or a parking citation. So we just naturally assume that those attitudes may have passed down across the generations, and that if anything, our ancestors were probably a little bit more upright than we tend to be. So it can be a bit of a shock to see them engaged with the criminal legal system of their time, especially when they are alleged to have participated in activities that we consider especially objectionable on moral grounds. But one thing I've learned in genealogy is you can never be prepared for what you're going to find when you start your research. The trick is to remain open and use those surprises as opportunities to burrow in a little deeper and to know your ancestors better in their full humanity, not according to the way you may have prejudged them. So you can imagine how I must have felt way back in the late 1990s when I finally managed to visit and interview an elderly cousin living down a dirt road in rural South Carolina. She was over 90 years old at the time. I had never met her before in my life, so I simply had traced the descendants of my relatives down to the present day from my great-great-grandfather, and she was the oldest cousin left. And I thought, I'm going to make contact with her. She still lived in her own home across a field by herself from where her daughter lived. And I had to go down there several times before she would open the door and call her daughter. She would agree to see me, and then I'd go down, and she wasn't there. So I called her daughter, and her daughter talked to her, and then she let me in. But she didn't know me at all, and I understood that totally, and it was worth it. So eventually we settled down in her kitchen, and she brought out her photographs and her memories. One of the photographs is the one that you see right here. My great-great-grandfather, her grandfather, is sitting there with two of the uncles, his sons, and the one on the left looks just like his nephew, who was my grandfather, just a spitting image of my grandfather. So when she was a little girl, her grandfather, my great-great-grandfather, actually lived with her father and mother. He was the sort of man who held fast to his children and tried to control their lives. I don't know if you've ever met a person like that before. Some resisted, like my great-grandmother, who slipped out of the cotton field one day with her wedding dress on underneath her work clothes and met my grandfather in his buggy at the edge of the field. And they went to the next state over to get married. Others, like her parents, remained close by and well within his control. So, second great-grandfather Stubbs had been a magistrate for most of his life, as well as a farmer. And he doted on those three granddaughters that he had that lived with him, one of whom was Maggie, the little woman that was speaking to me in her faded house dress. People called him Captain Stubbs, and he used to go visiting neighbors and friends in his sulky and carry Maggie along with him to meet all these people. And she remembered that. She remembered his favorite meal. She told me about the day that he died. A lot of what the family had been lost in a fire with a house burned down. It was struck by lightning. And the more I learned about my grandfather, the more I understood why it was struck by lightning. So he liked to tell her stories, and among those stories was a tale of how he had barely escaped the Civil War alive, all the bloodshed and the horrors that he saw, and how he'd been elected captain of his regiment in the Confederate Army. And it turns out that wasn't true. He was discharged from the Confederate Army because he had epilepsy, and he was never anything more than a buck private. I give him a little credit because he probably wanted to explain to his little girl, his granddaughter, why people called him captain. And the tales of his military bravery would increase his standing in her eyes. It was really because he was a justice of the peace that folks called him captain. And he was probably embarrassed that he hadn't been able to serve in the army because of his epilepsy. But at the time, I didn't know that. I was eager to get to the state archives to find out more about Captain Stubbs. But what she told me next made me want to know even more. I wanted to get to the archives even faster because she also just casually stated that he had once murdered a man. And it was his brother-in-law, in fact, that he murdered. She told me that. So when Maggie saw my stupefied reaction to that little revelation, she quickly tried to minimize its seriousness. She said, "Oh, he didn't go to prison or anything. It was justified." I tried to get more information from her about what had happened, but she really didn't know anything particularly about it. So I left the farm that day with a mission. It would be my very first real foray into court records of this type. And you can bet that I hurried my plans for that trip to Columbia to look into this matter as well as the Civil War service details. For the records, I looked at the higher criminal court records for Sherrod District, because that was the district in which Marlborough sat, along with Chesterfield County at the time. And the higher penalty crimes would have been tried at that level. And I found the loose papers, with the help of the archivists, a case entitled State of South Carolina versus T.P. Stubbs. I found the indictment, a formal charge of murder against my grandfather. I found a coroner's inquest into the body of Thomas M. Jones, who came by his death from a bullet in 1857. And finally, there were bits of recorded testimony or depositions that were taken from the individuals who were around at the time that this event occurred. There was information from T.P.'s sister, who was the wife of Thomas Jones, from his father, John Weldon Stubbs, who was also a magistrate, and his mother, Elizabeth K. Stubbs, and his uncle, Jackson Stubbs. And then there were several others. I also found the term in the minutes of the court where the case was actually tried. And I discovered that the judgment of the jury was that T.P. Stubbs had acted in defense of himself and his family. Thomas Jones was allegedly an alcoholic and a wife abuser, and he had followed his wife, who was trying to get away from him, to his in-laws' house where she had taken shelter. On the morning he swaggered up to their steps, he was carrying a brace of pistols and threatening the whole family if she didn't come out. So my grandfather was 20 years old. He was working in a nearby barn at the time, and there just happened to be a shotgun there. So he knew what he had to do, and he did it. And I wonder how it affected the rest of his life. The murder, the trial, the whispers. Did he ever second guess his actions that day? Did his sister appreciate what he did or resent him for what he did? But later, he was elected to the state assembly after the Civil War, and he became a magistrate like his father. The community, at least, thought that he did the right thing. I wasn't there that day. I was in no position to judge him or overrule the verdict of that time. But the experience of looking into the matter put me on a pathway. I gained an intense interest in criminal records, which I've carried with me to this day, and it led me to abstract and publish all the loose criminal court papers up through 1850 for the county of Randolph in North Carolina, which I serialized in the local journal over many years, maybe a couple years every year of the journal. And those were just terribly interesting and informative records, I have to tell you, because our records in North Carolina are so much better than the ones in South Carolina in terms of court records. They're more complete and they're just more detailed. Now, it's not just because I have a prurient interest in salacious and bloodthirsty details. I do actually have a prurient interest. In fact, most criminal matters, they involve minor, relatively unimpressive events, relatively short-lived, inconsequential conflicts between individuals. But working methodically through Randolph County's records actually gave me a deeper appreciation for the kind of intricate details these records contain and how monitoring a family over time with them can reveal a good bit about family members, their relationships with each other, and the dynamic between the family and other people in the community. And you learn also that families are more likely to commit crimes on one another than they are on people who are unrelated sometimes. For my personal research, I have since investigated criminal records for other counties, though I haven't published them. And those include counties like Richmond, Robeson County, Montgomery, and Orange. Recently, I was disappointed that, I'm the editor of the Guilford Genealogy, so I was disappointed that Guilford County's loose criminal papers are just gone. There are no loose criminal papers virtually for the 19th century in Guilford County. And so I thought, I can't do the same thing that I did for Randolph or Guilford. I'd just love to do the same thing for Guilford. Well, I started looking at, instead of the loose papers, I started looking for bound books related to criminal matters. And I came across something that I was entirely ignorant of, and that is state dockets. And those exist from 1811 to 1868 in Guilford County in 7 volumes. They contain so many details, not all that you could find in papers, but so many details that I was looking for. And I've now published all 7 of those volumes in book form, over 1,000 pages worth, all indexed for Guilford County. And in addition to that, I did one book for Rockingham County, the early years. I've done one for Alamance, and I'm going to continue that Rockingham sequence and then start a Davidson County sequence. So somebody here has got to start Stokes and Forsyth. That'll be your thing to do. So today, I want to introduce you to the myriad possibilities that criminal records can open for your research. Our focus here is North Carolina alone, but every other state has analogous records. The names of the courts and the record groups may be different, but wherever you're working, the essence of the sources remains the same. Consult a guide for whatever jurisdiction you're working on, probably from a state-level archive, to get guidance about how to proceed in a different place. But today, we will define criminal actions as opposed to civil actions, describe the court system as it existed in 19th century North Carolina, describe the criminal process as it would unfold in a minor criminal case with all the different types of records that you would find along the way with examples, discuss how you can find the records that you need, explore some examples from my past experience, which is the good part, right? And then leave time for your questions. And there just isn't any way that I can cover everything in an hour or even an hour and a half, so consider this just as a beginning step on a journey which will involve many hours of research and learning through doing. Be sure to have a law dictionary at hand, like older versions of Black's Law Dictionary, because there are odd legal terms that you'll come across, and they're not complicated. They mean something. You'll readily understand it if you just look them up for the most part. Many of them are in Latin. Another handy resource is Benjamin Swaim's The North Carolina Justice, which is a handbook for justices of the peace that was used in North Carolina in the early 19th century and covers all the basic legal forms and requirements for court administration and low-level judicial prosecutions. So it's reassuring to know that it's really plain language, because most of our ancestors who were justices of the peace, they were not legal professionals. They had not studied any law. They were just doing their citizens' work, and they had this handy guide to help them through it. You'll learn it too. So broadly speaking, legal cases are either criminal or civil in nature. Although there are procedural matters that are purely a matter of formality and not actually contested, and we call those ex parte proceedings because they're uncontested, I think we have a rough intuitive grasp of the distinction between criminal and civil, but I'm going to go through it anyway. A criminal matter is basically an action at law in which the state has an interest in prosecuting an individual or group or a corporation for violating a law. Penalties are punitive, involving the loss of liberty, fines, and/or bodily consequences, including things like whipping, branding, humiliation, mutilation up to execution, whatever the laws of the time prescribe. The laws in question are generally those that maintain public order, that protect private property, and the peace and safety of other citizens. Civil actions, on the other hand, are legal contests between private entities over trespasses, or harms, or wrongs, or violations of contracts or agreements which the state is empowered in law to enforce and assess damages. There are no bodily punishments in consequence of losing such a case. You won't go to jail, you won't be whipped, although there may be additional sums assessed to compensate for emotional distress caused by the defendant. The person bringing the case is usually a private entity, not the state, but it can be the state, or the state on behalf of someone else. So it's not the case that state versus so-and-so is always a criminal matter, but it usually is a criminal matter. In certain situations, the state can bring a civil action, for example, when a public servant, like a sheriff or county clerk, has taken out a bond to perform their office faithfully, but they fail to do so. They fall down on the job, so to speak, and then the state prosecutes them and gets that value of the bond back as a penalty against them. They fail to do what they promised to do. Bond is basically just a promise, any kind of bond, that you're going to do something, and if you don't do it, you may be liable to pay. The easiest way to tell a criminal from a civil matter is usually by its title, but if you've been paying attention, you know that's not always the case. For civil cases, it's private prosecutor versus private defendant, Jones v. Smith, and V is for versus. It can be V, it can be VS for versus, as against. The prosecutor is the party before the versus, and the defendant is the party after the versus. And multiple parties can be on either side of the versus, right? And if you want to put the defendant first, you do that with a different particle in the middle, and that is ads, ADS, period. You're going to index all the cases by defendants, for example, which they do sometimes. You can do that. And it would be Smith adds Jones instead of Jones versus Smith. Adds means ad sectum, at the suit of. That's all it means. See, all these legal terms, these Latin terms, they're just really easy to understand if you just know the code. For criminal cases, the state is the prosecutor. So when my grandfather was prosecuted for murder, it was state versus T.P. Stubbs. But if he had committed the crime during the colonial period, it would have been something different. It would have been Rex versus T.P. Stubbs. In Britain and the colonies, the king represents the state authority, figuratively, and crimes against public order are crimes against him as head of state. You'll note that the harmed party, that is Thomas M. Jones, isn't even mentioned in the title of the case involving his death. The state has taken up his wrong because murder isn't generally conducive to public peace and order. Now, there are cases when the state is prosecuting in a civil manner, as I've alluded to. Bastardy issues are the most common example. That's why the vestry, or later the county, requires a bastardy issue is when, I'm going to talk a lot about this in November, but right now, just a sort of an intro. When the vestry, or later the county, requires an unmarried pregnant woman, or one who has recently given birth, to reveal the paternity of her child so that that man can be brought into court and forced to pay support for the first 5 years of the child's life. So when she accuses a man and he doesn't automatically submit to providing support for the child and sign a bond to that effect, a bastardy bond, A legal case will arise in which the state represents the woman in her effort to get support. The state has an interest, but it isn't a criminal case. It's a civil case for damages, for basically support. Strictly speaking, the title should read State for Martha Jones versus Thomas Smith, for example. But it usually just reads State versus Thomas Smith, and you may see bastardy off to the side, or BAST, or whatever they're using for it. And it looks like a criminal matter, and it's often indexed and docketed like a criminal matter. And that's why it's so wonderful that we have criminal records and criminal dockets. Because even if your loose bastardy bonds have disappeared for your county, which is true of many counties in North Carolina for significant periods of time, if the dockets survive, the state dockets, those bastardy issues will probably be in that docket. Such a good thing to keep in mind. It's something I didn't know when I wrote my article about bastardy bonds for the North Carolina Genealogical Society back in the day. So it usually is usually interpreted and filed with criminal matters, even though it's civil. And sometimes archivists and local officials administering these laws are no better at making fine distinctions than we are. There are also cases like assault, where both a civil and a criminal case can result as a consequence of the assault. So let's say you get into an argument with your neighbor about whether the hedge dividing your properties could be cut down or not. And you lay into his hedge with your shears because you're just tired of talking about it. And he comes out and slugs you, and you accidentally injure yourself in the process. Not only can he be prosecuted by the state for assault, or be fined or jailed if the state thinks proper to bring those charges, but you can bring a civil action against him to recover damages for your hospital stay and your pain and suffering. And then he may be able to countersue you civilly for the damage that you did to his hedge. Now, ain't the law great? Litigation for all. The 19th century is basically divided at 1806 and 1868 when it comes to what courts heard what. Before 1868, all lesser crimes, misdemeanors, were cognizable before the Court of Pleas and Court of Sessions, which we also call the county court, just for short, which met 4 times a year, once every 3 months, often February, May, August, and November, hence quarter sessions. The judges for these courts were the justices of the peace for the county, like my grandfather. All local men, commissioned by the governor. Justices were not really necessarily legally experts. They were citizens of some renown, some note, but may not have had any legal background at all. All felonies, like murder, grand theft, or horse stealing before the 18 teens, which involved greater degrees of loss in terms of material or physical injury and more severe penalties, were the province of a different court, that is, the Superior Court. Before 1806, not every county had a Superior Court. We had what you call district superior courts in North Carolina, which covered several counties each. Guilford County, for example, was in Salisbury District, but Randolph County was in Hillsborough District before 1806. What district do you think Stokes County and Surrey County were in? Salisbury, right? Salisbury would be the district that you would have been in. But after 1806, each county had its own superior court. There was a less business for the higher court, so it sat only twice a year, and it also didn't have all the administrative duties that the lower court had. The lower court was also like a county commissioner's board. It did everything, including hearing the lower level cases. The justices came from the state level for Superior Court, and they rode the circuit. So the court days would be staggered so justices could move from courthouse to courthouse and hear cases across the year. They had to be professionals. They did usually have a legal background. Special terms of court could be called when there was a superfluity of cases on hand, too many to be heard in the normal term of a week. So keep in mind that both courts also heard civil cases, but at different levels of scale or seriousness in the lower versus the higher court. Now, after 1868, that's the big break at the bottom. And by the way, this chart you can get from Helen Leary's North Carolina research. That's what it's drawn from, and it shows the evolution of the courts through that whole period, and also the 18th century and the 17th century. But keep in mind, after 1868, the new state constitution was instituted after the Civil War. The Court of Pleas and Court of Sessions simply vanished. It went away. It was no longer in existence. And all cases, civil or criminal, whether felony or misdemeanor, were heard by the same court at the local level. It was the Superior Court which survived, but its functions were stripped of any of the local administration the county court or the Court of Pleas and Court of Sessions was responsible for prior to the war. But keep in mind that there could always be appeals. So if you as a defendant didn't like the verdict or thought that you were mistreated in the lower court, you could post a bond and you could appeal from the county court of pleas to the Superior Court, and from there, post-verdict, perhaps to the state Supreme Court. That is, if the Supreme Court granted the appeal, which was called a writ of certiorari, or cert for short. The importance of this is if you're doing research in a county where the records are lost, for the time that you're researching, you can check the index of the cases taken up by the Supreme Court, the state Supreme Court, that is. And it's indexed in a black file, a card file, at the North Carolina State Archives. It's also been, most of those case files have been microfilmed, and they have been digitized, and they are on FamilySearch.org. If you don't know what FamilySearch.org is, ask your neighbor. They probably know what you can actually do AI searching of the handwriting from those files for a name that you're kind of interested in. Just do a blanket search. Not that it'll always pull it up, because AI doesn't always read handwriting perfectly, but typically in a given court case, your name will be repeated several times, and it's going to get it close to right one of those times at least to get you in. So it's a great thing to have access to, which a few years ago we couldn't have even imagined. So even if the original case papers and the documents at the local level were lost, let's say in a fire, or maybe somebody stole the papers. You ever heard of that? Somebody going to a courthouse and just taking stuff out? We had an archivist, so-called archivist in Asheboro, Randolph County, who for years, from the time her husband, who had been a lawyer, died, was considered the county archivist before all the records were sent up to Raleigh. And she would just casually give documents to people who came to visit the archives. Oh, this is your family, you can take that. And I've heard that she got rid of some things that she was embarrassed about as well. But I can't prove it, I couldn't prove it in a court. That's what I hear. So that's another reason to be concerned that records could disappear. But if something is appealed up to a higher level, a digest of the case at the lower level, what happened could form part of that record, and you could recover some of the material that you've lost at the local level. Likewise, if a defendant thought he could not get a fair trial in his locality due to prejudice against him or prejudgment, he could ask for a change of venue. You can still do that today. So the court case you're looking for, if there was local prejudice, it could have been moved to an adjacent county. Guilford County got a lot of changes of venues from neighboring counties, for example. I've come to find out. Cases like murder. And by the way, there's a lot of variability between court records as to what survives and what doesn't from one county to the next. So the good news is that everything that does survive from the early 20th century and before has been gathered in a single place, and that is the State Archives in Raleigh, by county, under a category called court records. Pretty easy, under the county. This is not true in many other places. In Virginia, for example, a lot of local court records are still in the county. In Tennessee, I wrote to a local archive that they had there to get a court case, a paper related to a division of land in an estate record, because it wasn't kept. It's not gathered in Knoxville. It's not imaged in Knoxville. It's only available locally. In some counties, because they didn't have any room anymore, threw out a lot of stuff in these various other places. So we're lucky that we have the state archives who made an effort to go out and gather this stuff together. And South Carolina too. I have to give South Carolina credit for doing the same thing. I didn't mean to diss on them too much there when I was saying how less valuable the records were there, just less fulsome. At the North Carolina Archives, these are both original records and microfilm of original records for those materials that they couldn't bring to Raleigh, or they didn't want people handling as much because they were fragile. They might microfilm them. You can see what each county has in each category by using the online guide to county records, and it's on their archives website. You just download it and look and see what they have for the county that you're doing research in, both in the microform and in the regular paper records that they have. And there's also a print version that was done in the early 2010s, I think, the last version of it. So basically what survives can be divided into two types. Dockets. The dockets are bound records of a court's proceedings in abbreviated form. The minute docket is the most basic and the one that you're probably most familiar with, and it's important. It records all the business in brief from each term of court where a case was heard, chronologically by term. And as you go through the minute docket, you will find the names of cases at the left-hand margin of each page, described as, in the case of criminal, state versus defendant. And beneath that, you'll find a summary of what the court did with regard to that case on that day. For instance, if the case came to trial that day, the jurors would be listed with the verdict beneath, or if no verdict could be reached, it might be declared a mistrial. Cases could also be dismissed by the judge or settled by the parties. Note particularly when jurors are withdrawn in the minutes, that could happen because they have a prejudicial entanglement with one of the parties. So they can't sit on that case. They could have a business relationship. They could have a past quarrel. They could be relatives. That's the one you're really looking for. The sentence, and it doesn't tell you why. It just shows you this person's removed and replaced with so-and-so, and you have to ask why. Why was that person replaced? The sentence could also be given if they're convicted, and the plea. Reference to an appeal to higher court might be made, and the grounds given for such an appeal in a very legalistic manner. But very few important facts about the proceedings leading up to the verdict appeared in the minutes. The minute dockets are better for finding the duration and the outcome of the case. But there are a lot of other types of dockets as well, and these usually act as ways to keep track of who to appear in court, who is responsible for their appearance. That's the recognizance or the appearance docket. Cases across terms of court, the trial and reference docket or the state docket. Trial and reference is usually a civil docket, and the state docket is usually the criminal docket, always the criminal docket. Or record how and when judgments and court costs were to be recovered, and that's the execution docket. Because they could execute on your property to get what you owed them, whether it was a fine or cost associated with your case. If you lose your case, you could end up paying the whole wazoo, right? Each clerk of court might keep his dockets a little differently, so there are no rules, so they do what they please pretty much, but they do follow sort of a general pattern. So you sometimes have to sample them to be sure what to expect from them in any given jurisdiction. The best docket, besides the minutes, for our criminal interest are the state dockets. They're sometimes called a criminal issues docket after 1868. State dockets differ a little from one clerk to another, but in general they contain the names of all the defendants, all the people bringing the charges, all the witnesses summoned, people who secured bonds to appear or those who secured appeal bonds could be in here. They may also be in that other docket about recognizance and so forth. As trials continue across terms, they will be repeated in a grid format like you see here. from term to term until the trial is concluded. So your case may show up 12 different terms. It could show up over many years. It could be in abeyance because they can't find the defendant, but they'll keep it on there till they just give up. The Civil War was a big disruptor. So things that got dropped in 1864 could continue on to 1868 or 1869 before they finally got to the end of it. These dockets, therefore, will contain matters not in the minutes because they never got to the trial stage. You see a whole bunch of null process, nulle prosecutori. Right there in the right, you see it on the next to the last case. That means the charges are dropped, the case is dropped. That case might not be in the minute docket at all, but it is here. And you might want to be sure you get it. It might be of great interest to you. All the main people in any case are usually noted in the state dockets. That's what I really love about them. The big exception would be the name of the deceased person in a murder case, as we said earlier. You don't really get that name sometimes until you look at the papers. A dead person cannot be a party to a trial, and that name may not appear in the dockets at all. But the dockets are the quickest way to find what you're looking for and what terms of court apply to your case, so that you can then turn to whatever papers survive for those years from term to term for more detail. These volumes are a lot easier to skim than a whole bunch of papers, which may run to several boxes for just 2 or 3 years. But you're lucky if there are a lot of papers like that. I'm not trying to dissuade you from looking. And you run across things that you know the people that you didn't mean to look for, but they just happen to be there in the same box. There will be separate relevant state dockets for the county court as opposed to the superior court. The superior and the county have their separate state docket. Now in this state docket, for example, from Alamance County, we are at December the term 1850, and all matters here are criminal. The case titles and the order on the docket are extreme left. The third column tells us what kind of action is being heard. We see here indictments for affray, which is like a general melee fight involving a whole bunch of people, fornication and adultery, assault and battery, petty larceny, and there will also be bastardy issues in this docket. And I want to tell you, there are no bastardy loose papers for Alamance County for this period of time. So if you find some bastardy stuff in here, you're real lucky, right? You may not have ever known to look in the docket. We can also see whether an indictment has been brought and whether considered a true bill, and I'll explain what that means in a minute. In the fourth column are the individual prosecuting and the witnesses' names. In this case, for instance, issuing capious writs, dismissing charges. In the last column, you'll see what the court did as to certain individuals and not others, determining whether to proceed with the case or not. So the papers are a completely different animal. The dismissed court papers or dismissed judgment rolls collect all the documents that the court issued or received in bringing any given case to trial. So this is not the summary, this is the fullness. These include things like presentments, indictments, writs, summons, bonds for appearance, prosecution, or appeal, written affidavits or depositions if you're lucky enough to get those, witness tickets, and final bills of cost levied on the losing party. Now I rushed through that, but I'm going to go into each of those areas as we go forward. Do not, however, expect a complete trial record. That never happened in the 19th century or before. There were no dictaphones. Select details of oral testimony might be recorded in a memorandum for a higher court if the case were being appealed. The important thing to be gleaned from papers apart from written testimony are the names. All the people associated with the case, from witnesses to securities to the accused and the injured parties. And there are counties in North Carolina where you have all the papers you could ever wish for, but no state dockets. So you might have to resort just to looking through the papers. Orange is a good example of that. Everything is filed or recorded chronologically in North Carolina, not by the name of the case, as it might be elsewhere in South In South Carolina, for instance, we have files or bundles that collect all the loose papers pertaining to a single case. But that doesn't happen here in North Carolina. In fact, they still might have the twine wrapped around them and tied, that they kept them in the courthouse the same way. And everything is folded and you have to unfold it, which is very damaging, by the way, to the records. But here in North Carolina, everything's been flattened. It's been stabilized to the extent that it could be with, applications of various kinds for preservation. And then it's been filed by year. There could be multiple files for any individual year, and usually there are as you go forward in time. The archivists try to gather things related to the same case in the same year and the same together, but people are going through this stuff and they're unfortunately changing the order, or they just didn't get everything together. So you have to look at everything for a given year. So the bill of complaint is the first thing in a court case usually. So let's work through the process of a typical criminal matter. First, how does the case come to the notice of the court? Well, it can actually be initiated in a few different ways. The most common is for a complaint to be made before a magistrate or a justice of the peace. The injured person in the case or their representative will make a brief declaration of what happened and when and who is believed to be the culprit. That's what is called a bill of complaint, like the one you see here to the right that I've transcribed for you. Sometimes on the bottom of the document, there will appear an initial list of witnesses, if any, to or surrounding the alleged crime. And these are often the accuser's witnesses, not the defendant's witnesses. The court refers to the complainant as the prosecutor throughout the case, even though the court has to decide whether the state will actually prosecute the matter from here. And in this example from Orange County in 1782, that's how early this can go, John Robinson appeared before John Nichols, a justice of the peace, and claimed that one James Kemp, who was a deserter from the Patriot Army and already in jail, was the very person who took his mare, a black mare, 15 hands high and a natural pacer, in November of 1780, nearly 2 years before. Why did it take so long to prosecute John Robinson's nemesis here, James Kemp? Well, because the war was ongoing. So you look a couple, 3 or 4 or 5 years after anything that happens to see everything that may have resulted from it in the legal situation. Another possible way to bring forward a charge is through the grand jury. A grand jury is not the petty or trial jury, which actually renders verdicts. This is a different kind of jury, and it has two purposes. One is to bring criminal and other matters forward that need to come to the attention of the justices and the county officials, the sheriff, the deputy sheriff. The jury consists of ordinary citizens, but they're all going to be men. They're all going to be freeholders, have a certain amount of property. They're all going to be people considered to be of good moral character, whatever that happened to mean to the justices. And they're drawn from tax lists, by the way. That's where they get these names from. So if they know of a crime that happened in their community or they suspect one, they can declare it. And we call this a presentment. The witness names may also appear on this kind of document. They could be on the back or the front. So here's an example from Orange County in 1793. A grand jury presented 3 men, Thomas King, Claiborne Parrish, and Robert Duke, with living in adultery with certain lewd women. Thus they were guilty of fornication and adultery. Did you know that was a crime? It was in that time period. And think of the implications that this could have for your ancestry if you're descended from one of the women. The jurors all sign at the bottom. In this case, I don't think they really signed. I think one person did all that writing. They don't always all sign. The same thing's true of petitions, and you can usually tell one or the other. Likely they just had this information from the community knowledge and they're reporting it to the court. Whether the state's attorney prosecuted these matters is another question, because it's not easy to prove fornication and adultery, I can tell you. Finally, another way they were operated was through indictments. And that's when an officer of the court, like the sheriff or a constable, could make the accusation of their own knowledge and submit it to the grand jury for review. And that, the grand jury's second major function was to decide whether there's sufficient evidence to proceed to a trial. If they find that this is the case, the bill of complaint or presentment is then termed a true bill, if they make that determination. But if they file an indictment based on that, and indictments often have very formal language that should not be taken as an exact representation of what happened. If they find an accusation is not worthy of proceeding due to the lack of evidence or the lack of grounds, then they return a verdict of not a true bill, or ignoramus, which means we don't know in Latin. So here in August of 1801, an indictment is filed based on a grand jury finding of a true bill against Joseph Morgan, James Morgan, and William Flintham in Orange County for assembling at night at the house of John Abbott, breaking in the door, and attacking his wife Susanna. However, as I said, don't believe every detail that you see in an indictment as a statement of literal fact, because indictments often follow formal boilerplate language. The event definitely took place in August 1801, but it may not have occurred on the 1st. Whenever you see the 1st of a month, that may just be an approximation or general reference to the month. And it calls this action riotous and rootus. And I don't know how riotous and rootus it actually was, but those are just boilerplate words. So don't take that too seriously. May not have been as dramatic as portrayed. To what degree did they beat, wound, and ill-treat her and put her in great terror and peril of her life? Well, that's what it says, but it may or may not reflect how dire her situation was. They may have just pushed her aside and made her angry, and that would have been enough, entering her house for this indictment to take place. Then again, they could have done something horrible to her. I don't want to minimize it. We can't tell from an indictment. So the three ways to bring a criminal matter up are through an individual accuser, bill of complaint, through a grand jury, or through an official accuser. If the evidence is credible, the grand jury may level an indictment. The most typical charges brought against our ancestors in the court of pleas were petty crimes like assault, affray, theft of livestock, disturbing the peace, selling or buying from slaves. And why was that illegal? Because nothing a slave owned was considered their property. It was their master's property, so it was tantamount to theft according to the laws of the time, even if the enslaved people worked for it, even if it really was theirs. Selling liquor without license, obstructing or failing to maintain a road or a bridge, counterfeiting or passing counterfeit money or promissory notes, because remember, our ancestors at this time were cash poor. They were mostly working with IOUs. So conjuring up a promissory note that's not correct is a serious crime. Perjury, disturbing the peace, keeping a disorderly house. That does not mean that you're not a good housekeeper. That means that you're carrying on, selling liquor, having parties, maybe having sexual escapades in your house. That's typically what that means. Maybe a bawdy house, for example. Fornication and adultery and unlawful cohabitation. Living with someone that you're not married to, basically, in the biblical sense. So I should note that attempted rapes or actual rapes are sometimes masked as mere assaults upon women. So if a man is assaulting a woman, you may need to think about what's actually happening critically. The word ravishment or assault with intent to ravish is the usual explicit reference to rape. But then it could be very hard for women, then as now, to bring such a charge and have it stick because of community skepticism and potential repercussions for her. Next, it's time to bring that potential culprit in before a magistrate and secure him to appear for trial, or her. And we also have to bring our witnesses. And we have to inquire with the defendant if he has any witnesses to summon of his own. The document to bring the defendant in before a justice is called a capias writ. Capias is just a Latin word for you are to seize, or you are to take the person of this individual. It just requires that he be brought in before the magistrate. It does not imply incarceration. In this case, Stephen Redding came to the Justice of the Peace, John Cabe, in May of 1801, in Orange County again, and told him that Robert Allen was a person of no settled occupation, wandering about the county. He had left his family and taken up with one Sarah Smith as a means to keep himself from the cold. That's the bill of complaint part. But at the bottom is the capias writ. As transcribed, that should bring in Robert Allen to be examined and bound over to the court if necessary. There are no witnesses listed here, but often if there were witnesses besides Stephen Redding, they would be listed at the foot of the document, or they might be listed on the back of the document, as are the witnesses in the case against John Taylor, where no fewer than 8 witnesses are listed on this right-hand side document here, along with the tales of who served the writ or whether they were successful in serving. It might take several attempts before a capias writ could be served. An alias capias is the second attempt to seize the body. The plurius capias is the third or following attempt to seize a person. And they could be sending them all around to different counties trying to figure out where they are. If a capias or summons couldn't be served, you will often see "not found" written on the back by a sheriff or constable, or "not in my bailiwick or jurisdiction." If the defendant had skipped town, it could say "gone to Georgia." And it's not uncommon to see something like that, "gone to Texas." And that could actually be a clue as to where they went, according to their neighbors. I'll give you a good example of that. And this was someone that Larry will appreciate. So there's a warrant to take the body of Colin McCrae in Montgomery County, North Carolina, for a serious assault that was committed with his nephews on a man that they suspected of stealing from their store without being able to prove it. They came at night and they beat him in disguise. They did him grave injury to the point that he was in danger of losing his vision. Note that in this case, the constable served the capias. He encountered Colin McCrae near his nephew's house on the road, and the usual report is just a sentence on the back of the warrant. But here, the arresting officer gives us quite a story about it. He says that McCrae turned and escaped through the woods. And as it turns out, Colin cannot be found in the 1850 census, just a few years later, of Montgomery County. But there is, in fact, a man with his name, born in North Carolina, born about the same time, living in another McCrae household in Tennessee, Lafayette County, Mississippi. And I believe this is him. He decided to skip the area for a while and wait until things calmed down, and he did. He came back. And that was an implication that he's related to the people that he found refuge with in Tennessee. And he knew them. He knew where to go. But by 1860, he came back, and he died and left a will in Montgomery County. On the reverse of many capias writs are bonds made to appear in court on a subsequent date for the case to begin, and we call these recognizance bonds or appearance bonds. We have to remember that in this period, jails were small, they were expensive, they were poorly guarded and insecure, poorly built. The county never wanted to pay enough money to keep them in good shape. So ideally, only the most dangerous defendants or those most likely to flee the poorest or the most friendless were going to be placed in that jail pending trial. Most people could make their bond required to keep themselves out of jail with the help of some friends. They didn't have to put in any money. They just were acknowledging that if they didn't appear, they would have to pay the penal sum on the bond along with any securities who might sign the bond with them. And that might mean that the seizure of their land or other goods. Those bondsmen would also be liable if they could not produce the body of this person on the correct day or within a few days of it. So that was a risk. And you have to think, if those people aren't familiar to you as being county officials or somebody who had a tavern or something in the courthouse town, they could be very close friends, business partners, relatives of the accused person. they are doing something very dangerous. In this case, Christopher Stubbins had been brought in to answer charges of assault upon Thomas Watts. At the foot of his bond is a section headed State versus Joseph Stubbins Sr. and John Collins Sr. because they are his securities for appearance. If he doesn't show and they cannot produce him, they are in trouble too. The penal sum was 50 pounds, and that is enough at this point for many small farmers and laborers to have their farmsteads sold. Thomas Watts was also bound to appear and give evidence as a prosecutor on pain of the penal sum of 25 pounds. So if you make a charge and you don't appear to prosecute your case and help with the prosecution, you might be in trouble too. The implication is that bondsmen could even be entangled with the defendant. There were far fewer official bail bondsmen than today, and I've already talked about that. So witnesses have to be summoned as well, with or without security. Much smaller penal sums were involved on their bonds. If something happened to keep a witness from attending court, they'd often provide a written excuse that might be interesting. It might just be something like a dog ate my homework, It could be something like my wife went into labor, or, the creek flooded and I couldn't get across it, or I was terribly ill for a whole week. And that could be an event in your ancestor's life. It'd just be interesting to know that that happened to them. Note that any minors involved would be represented by their parents or guardians throughout this process, and women would be represented by their fathers, their brothers, or their husbands, or their guardians. So accusations on behalf of women were often prosecuted by their menfolk. Evidence. Most evidence would be produced orally in court before the full hearing of the jury, but no written record would be made. Occasionally, if the matter were particularly grave, like a murder, or if the witnesses couldn't come to court because of their illness or an age or distance issue, they might be deposed and the testimony would be set down in writing and entered into the evidence, and that's a great thing. You want to see this. You want to see them writing down what they know. In the case of a traumatic incident like murder or suspected murder, it was key to get statements fresh and close to the date of the crime. That's the real gold mine of these cases, if you're lucky enough to encounter it. We call these depositions or affidavits. So here's an example. In this extremely interesting case, Stephen Madden Jr. and Solomon Barlow went out deer hunting in the fall of 1793 and ended up shooting somebody's barrow hog instead of a deer. The question is, who was the culprit? Madden's written testimony accuses Barlow of luring him into the situation. Samuel Thompson was known to be the owner of the hog because of its ear markings, which he probably had registered early in his life or when he first came to that county. Note that Barlow took the carcass home to his father's house, and likely some of his family members will also be witnesses in the case, just in case you were wondering who his relatives were. A case could be continued for some time, as we've mentioned, as witnesses were marshaled, charges were contested or on points of law, quashed or dropped. But if the case continued, the jury was eventually impaneled and the verdict given post-trial. There was no transcript of proceedings in the early days. Juries may not have even retired out of the court to deliberate, especially in petty matters. They just kind of huddled and talked to each other. So cases could run at rather a rapid clip, one after the other. You have a lot of business to cover in a week. This is usually only a week long with all the civil matters and all the administrative matters and all the criminal matters. The same jury could sit across several cases in a row. And we talked about how some of them could be excluded, and you need to make a note of that. But the other side of the coin is that anyone sitting on the jury was likely unrelated to the defendant or the accuser. So that could have implications for some theories of relationship that you might have. You might want to note who those jurors with the same name as your accused defendant, who those are, because they're not relatives. They're just not going to be relatives. If a jury couldn't reach a unanimous verdict, a mistrial would ensue, and the state's attorney would have to determine whether another trial was worth the expense and the time. If the defendant was convicted, he could potentially appeal, provided he could provide another bond, and could give sufficient grounds to justify the appeal. Most appeals to the Superior Court would be granted. A brief record or memorandum of the case would be provided to the higher court. These memoranda are another important source of information of what might have been said in the courtroom at the lower court, and especially the Supreme Court records. So don't forget either to search for newspaper reports for sensational crimes that may enhance what survives from the court record. In criminal convictions, the penalties could range from a hefty fine to lashes on the bare back to time in the pillory in front of the courthouse. You thought that was just New England, but it was also here. It happened here. Even till the 1850s and 60s, you've seen people being put in the pillory. Do you know what the pillory is? Okay. To a few weeks of incarceration, depending on the era and the laws in force. One could also be sentenced to hard labor in the later 19th century on road gangs, railroad gangs. Prisoners could be leased for labor to private companies for mining, manufacturing, logging, turpentine production, or farm work. And this leasing was far more common for black people or people of mixed race than for white people. Also keep in mind with the higher court that far more crimes were punishable by death than you might think in former times. As many as 28 crimes as late as 1817 incurred the death penalty. North Carolina was known as a particularly bloody-minded state in this regard. Burglary, for example, when you're breaking into a house or closed space, was a capital crime, as were things like murder, rape, of course, highway robbery, bigamy, dueling, stealing enslaved people, enslaving free people for a time was a capital crime, horse stealing, counterfeiting, and arson. But for some of the less serious crimes in our view, benefit of clergy was available on the first offense. So you could read a passage from the Bible and have your death sentence commuted the first time. When you see that people have been branded in the hand or the thumb, it's usually for a crime like this. And the purpose is to give a clear signal wherever this person goes that they've already been convicted once for that offense and the next time may incur the death penalty. In the 18th century and the 17th century, even mutilation was not unthinkable. So cropping of the ears, for example, traditionally this was a penalty for perjury, believe it or not. When you see people making a sworn statement that they lost an ear or a nose in a fight, and a lot of people got their noses and their ears bitten off in fights, believe it or not, or cut off, it's to protect them from the implication that this was a judicially imposed punishment on them. Wow. Long prison sentences were just not an option until the foundation of Central Prison in Raleigh in the 1870s. In the antebellum period, penalties for slaves accused of murder, attempted murder, or insurrection could be harsher than for whites, including, I don't think I'm going to list these, but I think you could probably imagine them. And if you look at my online version, you'll get the full list. Imagine the difficulty of getting a fair trial for such persons. In this example, we have an order to the sheriff of Orange County to carry out a sentence of corporal punishment, 30 lashes at the public whipping post, to be delivered in 1782 upon a black man named Cy, which was short for Simon, but they are spelling it S-I-G-H, Cy, which I thought was very evocative, for harboring an escaped slave, a fellow named Cupid, the property of one Jesse Benton. 30 lashes was a lot well laid on, as they say. That's a lot of lashes. Note that enslaved people generally could be tried outside the normal process of a jury trial, believe it or not. They were subject to summary justice in what we call magistrates and freeholders' courts, consisting of a mere 3 justices of the peace and 4 freeholding white men, 7 instead of 12 people, in other words. Such trials do not appear in any minutes, just in loose papers that may have been filed, and this court existed from 1741 to 1793 in North Carolina. After that, all cases were cognizable in the superior courts. They continued in South Carolina, freeholders and magistrates' courts, until the 1850s and 60s. If you suspect your ancestor was sentenced to state prison, those prison registers are more open now than they've ever been in the past. So you can find the record of what happened to them after they disappeared. When you find that someone has disappeared from the census or from anything that you see, you may want to look in the state prison records. That may be where they ended up. And they may not have survived. A lot of people did not survive state prison. Beyond appeals, when a capital sentence or a long prison term was involved, you should try to determine whether a petition for clemency was filed for your ancestor with the North Carolina governor at the time. These appeals often provide testimony from the lawyers and the witnesses. Even the jurors and the neighbors may be sympathetic to the person that they convicted. Even judges were known to weigh in on the cases for clemency. Petitions included the signatures of many neighbors who might attest to mitigating circumstances regarding the crime or the background or general character of the defendant, the number of his dependents and their situation. These are to be found in governor's letter books or newspapers. They are not indexed. The only way you find them is go in after them, knowing that a capital sentence has been rendered and you want to see if something happened in favor of the defendant to save him from that fate. In this example, which is not the original document but an abstract that I made, an enslaved man named Bristow had been sentenced to death for the murder of Whitmill Robinson of Wake County. It was a particularly brutal sentence involving certain things. I'm not going to read it out for you, but these white citizens considered that Bristow would have been convicted of no more than manslaughter had he been a free man, and that his body should be subject to such things, indignities, they thought was unworthy of the state. And this petition came before Governor Hawkins. Finally, financial penalties and costs of the trial had to be collected. And among these you will find the witness tickets, in which each witness details how long he attended court, how far he traveled in both directions with all his costs. Because ready cash was scarce at the time, the witness might ask the court to pay this amount to someone else that they owed money to. The court might also prepare an overall bill of costs, and it would delineate all the legal fees involved, the cost of all the filings and the writs that were generated by the court. You had to pay for every single one of those documents that had to be written out. The clerk's fees, the constable's and the sheriff's fees for going out and doing their duty, the witness costs, so another chance to see the witnesses' names there. On the back, the constable assigned to collect might detail what kind of property that he seized to sell from a losing defendant, from a horse or a cow, right up to the entire tract of land or an enslaved person. Now, at other times, the state would pay costs, and there are two examples there. So, the main question in locating these records for the 19th century is not where they are. Almost all of them for North Carolina, surviving records are going to be in the state archives among the records. Supreme Court records, the state prison records, or the governor's papers as we've delineated today. The question is the most efficient manner of finding them. Eventually, when Family Search has perfected its handwriting decipherment and they have decided that criminal records are important, and they go in and digitize and all this stuff and that's subjected to the AI, it's going to be so easy to find all this. But for the most part, state dockets, criminal papers, they're only at the archives still. That's the only place you can do this kind of research. So for now, the easiest way is to survey the state dockets of both the Superior and the County Court for the relevant period of time for mentions of any of your ancestors. You find out what the cases involved, what the charges were, who was the charging party, who were the witnesses, and then you follow up, if possible, by going to those papers that are filed chronologically for all those terms of court and looking through them for all the documents. Unlike civil actions, very few criminal action papers have been imaged or digitized, and the minute dockets may have been digitized for the various courts, the other dockets, like the state docket, is not. So this research requires travel and patient work. And I'm going to just let you, because I'm going so long, I'm going to let you follow up on the two case studies that I give you at the end by going to Heritage Deep Dive. And you just listen to your heart's content. You can forward to those slides. I think I'm running out of time here, but I'm going to finish and say that these are just two, these previous instances are two, where criminal records have provided context for my ancestors' lives. I told you of a situation in which my great-great-grandfather committed murder, but I've also discovered a distant grandfather who was himself murdered in the 1820s in Orange County, and the only thing I knew was his estate file. It didn't tell me that he was murdered. And a first cousin in Orange County who murdered his sister because he disapproved of her marriage and was afraid it was going to take money out of the family. It was a late life marriage for her. He was hanged in Greensboro in the 1840s. I have found a situation in which a grandmother in Randolph County in 1842 swore out a warrant of the peace against her husband, my grandfather, for abusing her, and was supported by one of her sons in that effort. And it made sense of a story that somebody in that family told me, that there was one younger son who had just crossed the creek one day and joined a friend and never came back, and they never understood what happened to him. I kind of understand now why his father, his household was in turmoil. And by the way, that husband died the next year. I don't know what happened there. In other cases, these records have illuminated community and family connections I would not otherwise have noticed. Like that time when a woman named Rachel Wallace testified in the 1790s in Richmond County about a hog's decapitated head found in her father Barnabas Skipper's corn crib. She heard one of her brothers say that a couple other brothers and my ancestor Solomon Quick had put it there after stealing the hog from a neighbor and butchering it. And they wanted to hide the head because the mark was on the head that would identify the owner of the hog, right? And thus the implication taken with other incidental records I found suggests that Solomon Quick married one of the daughters in that Skipper family. So he was their brother-in-law and partner in crime. A caution before we conclude. When using criminal records, please remember that accusations are not convictions. And furthermore, even if there is a conviction, innocent people sometimes end up losing cases against them. After all, there were no Hercule Poirot or Miss Marple living in these communities to help them. Furthermore, these are adversarial cases, so each side is going to present itself as the righteous party. The testimony is not to be taken at face value in every case, and what happened on a given day between two individuals is not the full story, I guarantee you. Often these events were part of a larger history or pattern of conflict, of resentment and heightened emotions. Be careful in rendering your own judgments. I hope that you won't be daunted by the trifling bit of court jargon and process required to decrypt these rich sources of information. I also hope you won't find the structure of the records too imposing, but a little effort to learn, a little practice will put you in command of this research. In North Carolina, we are so fortunate to have all of our older collected court records assembled in one place.